Good evening, live from Houston, Texas. We do immigration updates every week. Today, what do we have today to discuss, Emily?
Today, we want to talk about a new bill that was introduced into the House of Representatives recently, H.R. 2315. It has to do with optional practical training, or OPT, for F1 students. This bill is seeking to eliminate it. So we'll talk about what's in the bill, who's supporting the bill, what is the likelihood that it may pass. So you can kind of keep an eye on that. And in the media lately, there's been lots of information about F1 students being detained, being picked up, having their SEVIS records terminated, having their visas revoked. The most recent one was the University of Minnesota student who had a DUI, who had the visa revoked and then is detained by ICE for that. So we'll talk about that, what it means for international students, what you need to be aware of. Also this week, USCIS conducted the H-1B lottery. So previously in March, we had submitted all of the registrations on behalf of companies that wanted to enter people into the lottery for new H-1Bs, and that lottery process was complete. USCIS uploaded all of the selection notices and informed us yesterday. So what are the next steps for those people that were selected? And lastly, we talked before about likelihood of travel ban, and now news is coming out that the travel ban with a list of the red and orange and yellow countries, 40 some odd countries, is being delayed or postponed, possibly indefinitely. So question is, does that mean it's safe to travel now if this travel ban is being delayed?
Okay, first thing, well, this bill, Emily, we do see very often that bills are getting introduced in the House, which was not supposed to be, because immigration bills are supposed to be introduced in the Senate, not in the House. And we see these things getting introduced. What are the prospects right now for this bill to be passed? What do you give the percentage of chance that the elimination of the OPT will become a law and will be effective?
I give it 10% or less. I don't think that this is likely to be passed. It's possible it may pass the House. The Senate is a different story. I don't think it'll pass there. And it goes completely against what Trump himself said. He wanted to staple green cards to people's diplomas when they graduated from U.S. universities. Practical training is an important part of those that are attending U.S. schools from other countries. So it's possible it may pass the House because there is a majority of Republicans in the House and they just need the simple majority, but I just don't see it passing the Senate, where they actually need 60 votes to get it passed. What do
And
you
I don't
think about
think,
that?
yeah, I agree with you, Emily, completely agree. And I think so people who are on a student visa right now, I don't think so they should panic right now, especially for those people who are on OPT and STEM extension. They will not touch already given OPT and STEM extension. For those people who are studying, I think so they should continue studying as if the OPT is going to be there, and most probably will be there. This is not going to become so. Don't change any of your trajectory, what you are intending to in your career life at this point of time, based on this introduction of the HR. This is introduced in the House, not in the Senate. Very unlikely for this bill to become law. So I just want people to continue with what they're doing right now.
Yeah, I mean, there's definitely tons of immigration bills that get introduced every year, and the majority of them do not become law. So I think this is not something to be overly concerned about it. Just because it's introduced doesn't mean it's actually going to happen. We've got one Republican, Arizona Republican, who introduced it, and there's 8 Republican co-sponsors. We don't even have the text of the bill yet to know exactly what's in it. It just says the title of it is to amend the Immigration and Nationality Act to eliminate the optional practical training program. So just something to be aware of, but as Raul said, no need to take any different action or be too concerned about it.
Emily, with regards to the F1s getting revoked, there are a couple of different kinds of, even I've seen F1s getting revoked. For people who are decent, I mean, I checked the history of this lady. She's perfectly clean. I mean, never, except that she said she had one parking ticket and not H1B. F1 got revoked though. However, though, she is not terminated from civil system. We have seen F1 visas getting revoked for especially people who have DUI. And in that case, though, normally what we tell people is, hey, you can continue whatever you're doing and you can continue getting the H-1B. Whenever you go to H-1B stamping, you definitely will have an hurdle there where you have to go to the medical examination and all those things. Now, having said that, though, there are some extreme cases that where we are looking into the news channel where people have supported the Palestinian and other things. Most of our audiences, they put their head down, they will go to study, and then they just want to probably, if they get a work permit, they will try to work. And so most probably they should not be scared of it. But what is this emails from the consulates that we are receiving a little bit more frequently than before, Emily?
Yeah, so it's definitely revoking of visas by the consulate is nothing new, especially in the case of DUI, as you mentioned. If there's any arrest while you're in the United States, there's a chance for that. So the consulate will send an email letting you know that your visa stamp that's in your passport has been revoked. So the next time you travel, you're going to need to apply for a new visa. These are generally referred to as prudential revocations, meaning we are thinking that you might be inadmissible because of the DUI, because you might have a drinking problem. Therefore, we are going to do the prudent and cautious thing and revoke your visa right now, with the opportunity for you to apply for a new visa in the future. If you can prove that you are not inadmissible, that maybe the charges were dropped or reduced down, or you don't have a drinking problem, those sorts of things. So it's not anything new. I think what's a little bit different now is the wording of the email is talks more about the potential for deportation, which is generally having a visa revoked if you are maintaining your status in the U.S. The visa revocation itself is not a ground of deportation. So they do say that they can terminate your SEVIS record. They're informing the school about the revocation and that this may make you ineligible for a future visa. So the wording of the email sounds much scarier than what it used to. And, we've even seen, the situation of someone getting detained by ICE after getting this kind of an email, having their SEVIS record terminated. But I don't think that's typical. There likely something else going on in that case. I think a lot of these cases that are getting the media attention, details later come out that there's more to the story of why those people were detained compared to just having a DUI or just getting a visa revoked.
The same subject, we have seen that in Minnesota for the F1 student who has a DUI, it's been covered by the New York Times, it's been CBS, Fox News, all the major news channels, that the person has a DUI and then he's been put in the deportation proceedings. I already have a lot of consultations coming in. Hey, what's going to happen? You told me that I won't be deported. Now they're telling me they're going to deport. And when I also, of course, we have told people that when you have a DUI or any arrest, there is a good chance that the visa will be revoked. That doesn't mean that they are illegally present in this country. That doesn't mean they have to leave the country. That doesn't mean that they have to stop working if they have OPT and STEM extension. Now, this particular email is telling, hey, we may come and deport you. And you have to, for the kind of people like you need to show your intent to depart to Customs and Borders Protection Unit, and you can fill this form out, and they're sending all these details to the people. And this is a legitimate email. It's not something fake. I mean, I checked it out though. And what do you mean? Does it mean that all the people who have any DUI will be deported, Emily?
Definitely not. I think this is just a kind of scare tactic, a way to get people to proactively leave the US, and then they'll decide not to let them back in, not to give them a new visa in the future. But I don't think we can routinely see people being detained due to a visa revocation when it's due to a minor criminal issue, a minor arrest or a DUI.
Yeah, and then please don't panic, guys. There must be some other story for the particular person who have been arrested and detained in Minnesota. All major channels are just reporting DUI. We have not have any official statement coming from ICE, Immigration Custom Enforcement, USCIS, or Customs and Border Protection people that they are going to deport the people who have a DUI. All the people who have DUI, they never said anything like that. So there may be some more story. This particular individual seems to be from either Turkey or Iran, seems to have, even though he may not have participated in a Palestinian or any of those things, we don't know the truth in that particular thing. But at this point of time, for those people who have no history of supporting Palestinian movement in United States, where I definitely, where no history of those people. And if you just have a DUI, don't panic right now. Because I got a call, I got a consultation. The guy wanted to leave. He said, I don't want to be detained, put in jail for 1 or 2 months before I go to India, which they are going to send it to me anyway. So I'm going to voluntarily leave the country. I said, no, they're not doing it. So don't panic right now at this point of time. If you are in doubt, consult a lawyer, make sure that everything is fine before you take any steps, any steps. So don't, this is the, time of fear, and government is creating fear. The media is hyping it up, and just because one guy gets deported, there are a lot of stories. The clients, we don't tell. I mean, when something is very bad with our client, will we come and tell Mr. John Doe, who is my client, did all those things? We don't. I mean, there is a lot of information we don't give it out of. We don't give our clients. If everything is good information, then we don't give the clients information. We give the general information. But please be careful, though. Don't get into this panic mode. If you get any email saying that your visa has been revoked, consult a lawyer. That will be best thing to do. And Emily, while all this is going on, though, then I know these are the genuine emails that have been received, genuine things, but there are some fraudsters that are taking advantage. And they are telling that you will be arrested immediately unless you pay me this amount of money. And you will. Should they trust those things, Emily?
Definitely not. No government agency is going to send an email or call you to ask you to pay money in order to fix whatever problem they're claiming that you have. So definitely don't fall for those kind of scams. You do not have to pay money to any government person who's pretending to be a government person. You need to make sure if you're getting the email notification, it does not say anything about money. It does not say anything about you'll be arrested. It's just a very straightforward email. So those tend to be legitimate, but anything beyond that is likely a scam. So you should definitely get that checked out. Don't take any action by paying anyone anything to be able to stay in the US.
I mean, I have never seen the USCIS, the government CBP, ICE, or State Department telling that they will wanting you to pay the money immediately, right now. And if they don't, and they are going to send you, the CBP officer or the ICE officer is going to come you to pick it up. It is not 99% fraud, guys. It is 100% fraud. It is 100% fraud. If they are asking you for money, absolutely it is fraud. So please don't fall into it, and don't let us tell your story next time that you paid some money to somebody. That's very bad that you did that. You'll become a big fool. Don't pay money to any of those people. Also, there are some emails that I have seen, Emily, AR11, where people are supposed to change the address when they move from one location to another location. But of course, we have never seen USCIS enforcing, or any department enforcing this thing. That yet we did have a lot of the fraud people, companies sending that, hey, you changed the address, you did not fill the AR11, and since you didn't fill the AR11, the police is going to come and arrest. Is that true, Emily?
Definitely not. It's not something that you can be arrested for, and it's not something that you can pay money for in order to fix. They're never going to ask you to pay money in order to fix your lack of doing an address change, or really any immigration status. That's not how our system works. So definitely avoid falling for those scams as well.
Okay, lottery system, Emily. They say that the lottery system is completely over. In the first round, at least. We don't know whether there will be next rounds or not. And what are do you know the percentages got selected, Emily?
So we
They don't
don't
give it.
know, right? USCIS did not publish any numbers about the number of registrations or the number of selections. Looking at the data within our firm, we're in the 30 to 40% range of selections. Have not really broken that down by regular cap or master's cap. I think, for my personal cases, I somehow this year ended up with more bachelor's cases than master's cap cases. So my percentage selection was maybe a little bit lower than others in our office. But overall, it's somewhere in the 30 to 40% range. So now that we have those selection notices, the filing window for the actual H-1B petition, the I-129, has opened as of today. You have until June 30th to file that application with USCIS. Don't wait till the last week to file it because if anything is wrong with that petition, they reject it. You won't get it back until after June 30th, and then you've missed your chance. So please file early. If you have OPT that's expiring before June 30th and you want the cap gap extension, the automatic extension of your OPT, you need to file before your OPT expires. Your deadline is different if your OPT is expiring before June 30th. But the cap gap is lasting longer this year. It goes all the way till next April, an entire year. So that's one nice update that we have this time around. And we also have the option for H-1B beneficiaries to have their own company sponsor them. So we're seeing a little bit of people taking advantage of that this year. So we'll see if there's any kind of different requests for evidence maybe we get in those cases. We don't know if there's going to be new requests for evidence dealing with wage levels like we saw before, or dealing with specialty occupation like we saw before, because we do have kind of a new definition of specialty occupation. They got rid of the language about the employer-employee relationship, and now they want to see a bona fide job offer. So we may see some different types of RFEs related to that. I think for people applying from F1 to H-1B, doing a change of status, we're likely to see RFEs about whether you maintained your F1 status, particularly during your OPT time. And if you had any unpaid internships during that time, you need to be very careful in responding to that. You have to make sure it's clear that the unpaid internship qualifies to be unpaid and specify that. Otherwise, sometimes they would decide that it's not really employment and they consider that as unemployment time. And if you exceed the 150 days of unemployment time, they can deny the change of status because they say you violated your F1 status. So those are some of the top things to just be aware of. Also, travel around this time. If you file a change of status to H-1B and then you travel while it's pending, the change of status portion gets abandoned. So you're going to get an approval without the change of status, no I-94 on it. You'll have to activate it later. So if you're going to travel between now and June 30th, either file the petition and premium, get it approved first and then travel, or travel, come back before June 30th and then file so that you don't automatically abandon your change of status.
Emily, if I am in United States on F1 visa or H4 visa, and I'm working with that company, and especially F1 visa, OPT and STEM extension, and the company is telling that I'm going to save the money because of the taxes, of course, I will end up, if I'm an employee, I will end up paying extra approximately 6 to 7% of taxes, and the employer is going to end up extra paying 6 to 7% taxes. And they're telling me to do the consular processing to save the taxes. Is it a good idea?
No, definitely not. It is not worth saving a little bit of money, because when you do the consular processing, you're going to get an approval that's valid for 3 years, but you have to activate it. In order to activate it, you have to leave the US and apply for an H-1B visa stamp and be issued that stamp and then come back. We've already talked a number of times that travel is not safe during the Trump administration over these next 4 years. There's no guarantees that you're going to be able to easily get a visa interview appointment. There are 221Gs, administrative processing, lots of delays at the consulate. There's no guarantee you're going to come back. On top of that, let's say a year from now, you're still on your STEM OPT, you have this H-1B approval for consular processing, and you lose that job. Well, now that H-1B is useless. You can't transfer it to another employer because you were never granted the change of status or admitted to the US and H-1B, never got the visa stamp. So it's a waste of a lottery selection to file in consular processing. The only people I recommend consular processing is if you're on L1 and you don't want to automatically convert to H1, or if you have travel plans to where the timing doesn't work out. But otherwise, if it's the purpose of consular processing is to save a little bit of money on the taxes, it is not worth it. Not a good idea at all.
Emily, if I am not selected in the lottery, what are the options? Of course, more than 60% of the people have not been selected in the lottery, Emily.
Yeah, I mean, if you have to look at the list of other available work visas, the easiest thing if you're already in the US and you're on OPT and you qualify for the STEM extension is to file the STEM extension. That buys you another 2 years to potentially go through the lottery 2 more times. You can always, if you're at the end of your OPT time, if you want to continue your studies, you can re-enroll in F1 classes at the same university that you graduated from, or you can transfer to a new university. We don't recommend these day one CPT schools. I know the idea of being able to keep working is definitely a good point of that, but the short-term benefit of being able to work temporarily is definitely weighed against the long-term possible problems of that. We're seeing people later having trouble with visa stamping or seeing change of status denials. We don't know what the Trump administration is going to do with these types of schools. They may cancel their SEVIS, so it's just not worth it to do that. Other options, maybe you are have the family-based immigration option, marriage to a U.S. citizen. Maybe if you are from a country that is not backlogged, proceeding with the green card process could be an option. An O1 visa might be an option. Nonprofit organization that's either a research organization or affiliated with a university. So you can file a CAP exempt H-1B. If you're from Canada or Mexico, you have the TN option. If you're Australian, you have the E3 option. If you're from any of the treaty countries, you have an E-visa option. So there are some other options. If your company is a global company, they could send you abroad for a year, maybe come back on an L. So there are other options. They can be somewhat limited depending on what country you happen to be from. But definitely now is not the time to get desperate about it, because desperate people tend to do stupid things, and we don't want to do anything stupid when it comes to your career, your immigration, your future. It's not the end of the world. It's certainly not a great situation, not a great process that we have, but it's not worth ruining your chances for the future by doing something not smart.
Emily, now, right now, previously about 2 weeks ago, 3 weeks ago, you stated that there will be a travel ban. There is a red list, orange list, yellow list, and you have told not to travel and everything. And now it seems that it's been postponed. Now, is it a time right now for me? Let's say I'm from red list or orange list or some country. Let's say I'm from Pakistan, it's in the orange list. And is it right time for me to travel right now? Because before the travel ban comes out.
I still don't think it's safe to travel because even if we don't have a specific travel ban, there's always going to be increased scrutiny of those particular countries at the port of entry. Or if you're going for visa stamping at the consulate, you may not get the visa. You may be turned around at the port of entry. There's a possibility of expedited removal, which bans you for 5 years from coming back. So even if there isn't a travel ban in place, it is not a good idea to travel right now if you're from one of those listed countries. If you're not from a different country, we don't recommend travel if you need to get a visa stamp, because we cannot guarantee that you'll be able to get the visa to come back. We've already seen them eliminating Dropbox appointments. Then they canceled 2,000 visa appointments that were supposedly obtained through these bots. And then we're seeing more 221Gs, more administrative processing. The consulates are doing a lot more background checking into the projects, making sure that you have work available, sending emails to the end client, sending emails to the employer. There's a lot of follow-up that's happening behind the scenes that can delay the entire process and leave you stuck outside the US for months.
And one thing people should not forget is that it's been postponed. What does that mean? I mean, when you're outside the country, what if next week the guy puts it on and then now you're not allowed to come into United States? So it's definitely not advisable for you to travel at this point of time. That's our advice right now. Emily, Visa bots appointment though, there are 2,000 Visa bots appointments that people were paying almost like $1,000 to $2,000 for these companies in areas where the appointments were very tied up because the B2 appointments are backlogged by about 2 years. But if you go to these people, you pay them $1,000 or $2,000. They were charging a hefty sum of money. And just to get the visa appointments, and their visas are canceled. Their visa appointments are canceled, not visas. Sorry, I take back. Visas appointments are canceled. Now, is there a chance that those people who already got the visa stamping through these bots, can their visas be affected because they paid the money for these people to get the visa appointments earlier than what they're supposed to?
I think it's a definite possibility. The Department of State has been coming out quite a bit recently, reminding people that even after we issue your visa, they continue researching, they continue looking into your background and your activities, and they can always revoke a visa going forward if they find new information that wasn't available at the time. And so if they are thinking that this appointment was gained through fraudulent means or through a misrepresentation, and even if you're not the one that did it, if you're the one that, booked this company, paid this company, and the company used fraudulent means, that's tied to you. And they absolutely, I think, could go back and revoke a visa for those people. I'm sure they're tracking it now that they've been able to figure out how it's working and who's doing them. Yeah, it's definitely something to watch out for.
Emily, do you have anything else before we go to questions, Emily?
Nope, I think we can go to questions now.
Manasa is asking this question that her child is born in United States. I'm assuming before February of 2025. I mean, after February of 2025, of course, we know that there is a stay order on it. But, if the child is born before February of 2025, I can clearly say what the rule is. And US-born child, can the US-born child live in India for 6 months, more than 6 months, and come back into United States? I'm assuming, Manasa, that your child already got the US passport. No problem for this your child to travel for more than 6 months and stay there and come back in the United States. Can the child stay for the next 18 years and still come back to the United States on the US? Can he still get the US passport extended and come back? Absolutely not a problem.
Marsh says, would a person be considered out of status if an employer was acquired and the new company did not file an H-1B transfer before the change in payroll? Not necessarily. Many times in the case of an acquisition, the new company that's starting to run the payroll qualifies as what we call a successor in interest. And if they do qualify as a successor in interest, that means that the new company is your same employer as your old company. And the new company can start running your payroll. You can move everything over to the new company, and a transfer is not required in that situation. The company does need to update some documentation in their public access file for compliance purposes, but it has no impact on your status. Now, if the company does not qualify as a successor in interest and you started working for the new company without a transfer being filed, that can put you out of status. So definitely need to have your employer discuss with their immigration attorney, understand how that acquisition occurred to make sure that whether it qualifies as a successor in interest or not.
Question from Gautam. Have you seen any problem with people who have an advance parole traveling into United States? Absolutely not. We have not seen any problem whatsoever at all for the people who have an advanced parole who traveled into the United States after Trump came into power. Where all these rumors are flying around is that there are some advanced parole people that were being taken into secondary inspection. Sometimes the officers, the CPP officers, don't have the facility to do the inspection of the people who are coming in advance parole, and they have taken into secondary inspection after 10 or 15 minutes, speaking with them and verifying their basic information. They were let them go. Now, this was even before the Trump administration. It was like that. Nothing different, though. So we always told that at the time when you're coming in advance parole, you could be taken to the secondary inspection. Don't worry about it. And not a single person we know, because we have this channel, we do have a daily conference call, we do have a consultation, we are a big law firm. We have never seen any problem for advance parole people coming into the United States.
Paul says, is it safe to transfer jobs under the current administration using AC-21? He has an approved I-140, I-485 pending for 2 years, valid EAD and AP, currently on L-1A, but would lose that if changing jobs. It is generally safe. AC-21 has not been impacted at all by the Trump administration in the past. We don't see any likelihood that it will be in the future. It's always been very broadly interpreted. It's been around for over 20 years. I have never seen a 485 denied because someone used AC-21 in 20 years of practicing. So it is safe to do that. You're right that you do lose the non-immigrant status. So that's the one thing to be somewhat cautious about. But even still, having the approved I-140 means that your 485 is generally, in most employment-based cases where there's no prior immigration violations, no arrests, no criminal issues, it's relatively safe to forego the non-immigrant status and rely on the EAD and travel using the AP. One of the biggest problems is if you need to renew your AP, processing times have been very long, so there may be a time when you're not able to travel, but the 485 itself has generally been fine when people are changing jobs using AC-21.
Emily, I need attention on this particular gentleman. He is Egyptian national, and he never participated in the Palestinian movement here in United States or anywhere else. But some of his Facebook friends and other people may have participated and have voiced it on the Palestinian front. Does he need to fear? This is coming from Facebook.
I mean, I don't think so. With Facebook, you have your posts, but if you're not the one posting about it, I don't see how they can somehow claim that you're part of that just because you're Facebook friends with people who are posting about that or who have taken part in that. So to me, it's pretty unlikely as long as you are not posting about it and you're not taking part in
I
that.
agree
What are
with
your
Emily.
thoughts on that?
I think so. This is not for everybody who is in the United States from Middle Eastern countries, at least at this point of time. It's only for those people who have actively participated and probably taken some leadership role in the Palestinian movement, though. The reason what they're telling is that especially supporting of the Hamas, according to US law, it's a terrorist organization. Their aim is to wipe out the Israel. So they don't have any peaceful methods. And since you're supporting that, you're supporting the terrorist organization. But if you are not taken any part in the rallies or anything like that, I don't think so. You should be living in fear. You should be fine. That's my opinion.
Rajan says, I entered the US on AP. Am I still on H-1B? My company lawyer is not giving a clear answer. And can I go to Canada and come back into H-1B using automatic visa revalidation with my expired visa and valid I-797? So the memo is a 20-year-old memo that says that people who are on H-1B or L-1A or L-1B, H-4 and L-2, can choose to travel on their H or L visa or on the advanced parole. And once they enter on advanced parole, they can still continue their H or L status. So assuming that you're still working for the same company, same job, same terms and conditions of employment that were mentioned in your H-1B, and the company is following all the LCA regulations, you can consider yourself to be in H-1B status. It's not necessary for you to travel and come back on H-1B using automatic revalidation, although you could do that if you wanted to get an I-94 that specifically says H-1B. The only purpose that you'd really do that for is if you're planning on filing another 485. So you have that non-immigrant status, but otherwise, for all intents and purposes, you are in H-1B status, even though you entered on H.
Imran from Facebook has this question. He's a green card holder. He has only one single speeding ticket. Will that create any problem for his green card or citizenship? Absolutely will not be a problem for you. You don't have to, you are absolutely fine. No problem for you to retain the green card, travel on the green card, get the citizenship on the green card. If you were to file for your spouse or children, will that be any problem? Absolutely not a problem. Sachin from Facebook has this question that what do we need to watch the social media for? If I criticize Dodge, which is being here to eliminate some of the government departments, whatever the political things that are in there. So if I criticize that, is that going to be a problem? I don't think so. That's a problem. That if you criticize Dodge or support Dodge or criticize Dodge, I don't think so that it will be an issue at all. They were only speaking about the organization Hamas, which is a terrorist organization, and some of the terrorist organizations. People have voiced their support for that. People have voiced their support for complete elimination of Israel on the Facebook. They have done the rallies, and this government is going, or at least at this point of time, is going only after those people. So I don't want to be live in a fear that you cannot criticize Dodge or you cannot support Dodge or similar kind of things. I mean, especially the Indians have grown up very well. We are grown up in, it's a discussion. We don't discuss sports that much as we discuss politics. And then we have difference of opinion in politics. And then we do make arguments against our own friends and family members, and we respectfully disagree with their arguments, whether in support of Dodge or any those kind of things. There's nothing wrong with it. I don't think so. You should be that concerned about it. If it's only about any terrorist organization, which I did mention to you before, then you should be very careful if you were to get involved into social media of those kind of things. But Dodge or similar things like that, you can voice your opinion. You're fine.
Kieran says, I was laid off from the company. I have an EAD. My company also revoked the H-1B. Is there any issue with immigration? Well, you kind of have two things that you need to be aware of, your H-1B status and then your 485, which I'm assuming that's how you have the EAD. So when it comes to your H-1B status, assuming that the I-94 of that H-1B has not yet expired, you do have the 60-day grace period, even though the company already withdrew the approved H-1B because of the termination. So the grace period starts from the day of termination. You have 60 days. You can file an H-1B transfer. If you can't find the new job in time, you can file a change of status to B2 to ask for an additional 6 months to stay while you continue to look for the job. So that's the H-1B side. And then you can file a change of status back to H-1B once you have that new job, even if the B2 is still pending. On the 485, there is no grace period. You have to have a job that supports the pending 485. So that's going to be a job that's similar to the job that you were originally sponsored for on your labor certification or on your I-140 if you were directly filed under EB1C, for example. So as long as you find a new job that's similar, then you qualify for AC-21. If your 485 has been pending for 180 days, hopefully your I-140 is already approved. And you would need to be prepared to submit that 485 Supplement J form in the event that you get a request for evidence asking for it, or if you get called in for an interview. And so you need to be aware of both sides of that. If you wanted to forego the H-1B status, you could just rely on the EAD and use that to find the new job, but you still need to make sure that that new job is in a similar occupational category compared to the one that you were sponsored for.
Emily, I want to debate on some issue here with you. And this gentleman, Ahmed Dobi, has this question. Why are you guys not recommending day one CPT colleges? We have been historically, we never supported day one CPT universities. We always told that there is a very bad element to this thing. They can be eliminated. We've been telling it for a long period of time. I mean, we've been telling for 7-8 years. Yes, we know a lot of people who have gone to day one CPTs. They may have got benefited from those day one CPTs. Yet, we don't recommend it. I mean, at the same time, we said that before 2023, many years ago, and continuously saying that multiple filings of the H-1B was bad. What happened? They started revoking, and they're still revoking the people who have filed multiple H-1Bs with different companies. So that happened. Now, day one CPTs, we've been recommending from past 8 years, 9 years, we've been telling the same thing, day one CPTs, universities. We know that a lot of people are at desperate situations that they want to, but we at Reddy Neumann P.C, we cannot recommend to do some illegal activity. Why is day one CPT illegal? Is that, first of all, they don't require, we are here in USA to go to college on F1 visa, okay? I assume that there are some H4 visa people, H1B people, they want to do college and they can do online, that's fine with us. H4 people and H1B people. If you're an F1 people, the only reason you're in the country is to go to college and you're not going to college. That's one reason. Second thing is that most, if you don't believe us, these are illegal, but trust on this one, that 99% of the universities do not give day one CPTs. And name one major institution, Harvard, Yale, I don't know, whatever, University of Texas, University of Florida, University of South Carolina, University of North Carolina, University of California, University of, I can name so many universities that don't give day one CPT universities, that don't give day one CPTs. And so if these 5 to 10 universities are giving the day one CPTs, that is a good indication for you there is something is wrong. And there's another indication I will tell you. There were 2 sting operations in United States. One is University of Northern New Jersey. You can Google it. And there is another thing called Farmington University. These are sting operations. What sting operation is that? The Immigration Customs Enforcement opened these fake universities and recruited people. Hey, we are going to give you day one CPT. We don't, and they recruited the people and they deported a lot of people in the Farmington University. Emily, what are your thoughts on the day one CPT? Why? Maybe the whole other people are telling day one CPTs are legal and you are standing the other way around.
Yeah, because we see the cases where it didn't work out multiple times. I mean, when CBP officers at the port of entry say that these schools are pay-to-play schools, you are basically just paying tuition to be able to work. You're not coming to study. When people can't even say what city or state their university is located in, when people come into the US to live in a completely different state, nowhere near the school, and all they're doing is working. They travel to the school 3 times a year to take some random classes. They're doing the rest of the things online. Why do you need to be in the US to be doing online courses? You could do that from your home country. On top of that, these schools are issuing CPT after someone who's already used up all of their practical training at the same degree level. The regulations say if you use up your OPT, you cannot get more practical training at the same degree level. So people were getting denied the change of status from F1 to H1 because they would do their F1, they graduate, they get their OPT, their STEM OPT, didn't get selected in the lottery. So they go to a day one CPT school, then they get selected the following year, and they're doing the day one CPT for another master's program when they've already completed a master's program. And those change of status were getting denied for that exact reason from USCIS. So CBP says that this is a pay-to-play school. USCIS says the CPT is not properly authorized. And even ICE, when they're also considering this to be a pay-to-play school. I mean, we see the transcripts of people who've been interviewed at the port of entry, and that they can't answer anything about the school. And as you mentioned, no other normal school provides this type of CPT. That's a great indicator that these are not proper. You're not coming to the US for the purpose of studying. You're just going to that school to work. You're getting the exact same degree level that you were before. And after USCIS started issuing those denials, guess what? These schools came up with a PhD. Who needs a PhD in any of these things from these types of schools? That PhD is worthless. It's not going to help you in your career at all. All it's doing is providing you a way to continue to supposedly study when you're actually working the whole time. So it's just a matter of time that these schools get shut
And
down.
the administration is aware of it because before, when in the Biden administration, the organization called newspaper organization called Brit Brat. That's a main organization that supports the Trump administration, has clearly done an article on pay to work in school here in United States. So that's definitely an indication that Stephen Miller, who is in charge of immigration, is aware of it. We don't know when the action is going to take him. But when the action gets taken, though, it may make everybody who is on those particular universities become completely illegal. So definitely we cannot recommend it. It's up to you what you guys want to do.
Paris says, are FDNS site visits only done at the work site, or can they come to our home as well? And what triggers an FDNS site visit? So they come to the work site listed on your petition. So if you are working from home and your home address is listed on your petition as the work site, they could come to your home address. What we see more often is they come to the employer's location, and then sometimes they will email or call the employee and have you kind of fill out answer some questions over email many times. So I would say it's not that often that they come to the employee's home address unless there are other issues involved with potential violations. What triggers FDNS site visits? A lot of them are just random. They do randomly select a certain percentage of petitions to verify that the information provided in the petition is actually happening, that it's a legitimate job, legitimate company, to just maintain the integrity of the system. But they can be triggered as well. I mean, we see a lot of site visits happen with these companies that claim they have a so-called in-house project when they don't actually have an in-house project. We see site visits happening where companies were involved in the multiple H-1B registrations, working together with other companies to register the same groups of people. And then again, they are just random. They tend to be more common for third-party placement if you're working at a client location, working for a consulting company. Those are the main things that trigger them.
Sindhuja is asking this question from Facebook, that she is on STEM extension. Is it right time to travel? Definitely not. STEM extension goes through a lot more scrutiny, though, so I would recommend that you do not travel. Kavya from Facebook has this question. She has been working on F1, full time for 10 years on H1B, and she's going for visa stamping. I would say that if you're going for Dropbox, the risk probably will be around 2% or so. But if you're not eligible for Dropbox, you're going for the interview, the risk is a little bit higher. I would say about between 5 to 10% of the time. Then a lot of people ask question, look, I'm working for the best company that's possibly there. I'm making good amount of money. And I've been very decent. I have a house in United States. I have a husband who's working. My child is going to private school and whatever not. And why is that I get the visa 221G? Well, this is simple. The Trump administration doesn't like immigrants. Now, the visa officers, they're jealous of you. That's a simple word that I would say. They're jealous of you. They may be feeling that if you are being stopped, some US worker is going to get the job that you're doing. It may be. Now, that is not the reason for which why they can deny it, but that is something that they may have it at the back of their mind before they deny, before they give you 221G or deny your visa. So be careful on these things. That's all I would say. As I said, if it's visa stamping, if it's a full-time company, 5 to 10%, and if it's a drop box, 1 to 2%, if it's a full-time job.
Challenger says, I have my visa stamped until October 2026. I have a transfer in process. If my transfer is approved, can I travel to India with my existing stamping, or do I need to go for stamping? Your H-1B visa stamp that's in your passport remains valid until it expires, as long as you are in H-1B status with any company. So even if that visa has the old company name on it and has a shorter duration than your current approval notice, that visa is still valid. You can use it to travel. You don't need to go for stamping again. When you're coming back in at the port of entry, don't just throw your passport onto the counter and let the officer do whatever they want. Open it up to that visa and pull out your original I-797 approval notice of the transfer, the new company. And make sure they give you the end date that matches your new company I-797 approval notice, because sometimes they will mistakenly give you the end date that's on your visa, especially if you don't give them that I-797 approval. They have no idea of knowing, so they're just going to match the visa. So you want to make sure that you have the correct end date given, but no, you don't need to go for stamping in that situation.
People are asking me to comment about the G325R, the registration requirement for people who have turned more than 14 years once they entered into the United States. Now, if you are on a non-immigrant visa, guys, and if your child has traveled into United States before the age of 14, you have any doubt whether you should register or not, please go to USCIS website. It's G325R. It's free. It's online. You can do it by yourself. And you can go to our rnlawgroup.com. I put a blog there, how to fill the information. There are some questions that are a little bit doubtful. I've given some samples how to answer those questions too. So you can fill by yourself and submit. Have absolutely no problem in doing it. There is one column that it says that how did your child enter into the United States? It only gives enters without inspection, and it doesn't give any other option. And we have clearly mentioned to pick that other option, which is blank. It doesn't have H4, it has EWI. You pick that option and you do it. But this particular gentleman who asked me this question in the YouTube, the child is already a green card holder. Now, there is no G325R for people who are green card holders, though. Of course, there are some rules with regards to if the child has turned 14 after they came into or they got the green card, that form is called I-90. And if you have any doubt, and this I-90 may require you to, it requires you to pay some fees, not a big amount of fees, and you can do it by yourself. It doesn't require a lawyer to do, unless the child has some criminal history or anything. Definitely we tell you to contact an immigration lawyer. But if the child has turned 14, you can fill an online I-90 form and pay the money online and get the new green card. It's not a registration. Get a new registration with a new photograph, because they're going to do biometrics, because before 14, they don't do biometrics. After 14, they do biometrics. You can get that thing done online.
Vivek says, how is the H-1B extension approval rates right now? Are they getting extended for a full 3 years? No issues with extensions filed by the same company for the same job. Routinely getting approved for the full 3 years. No problems at all right now. We'll see if that changes in any way with the new definition of specialty occupation, or if any changes in wage level requirements happen. But as of right now, it's no changes.
Domestic visa renewals, I don't think so. It's in the menu of the Trump administration right now. If the question this is coming out is that if I get selected in the lottery of H-1B, I'm doing PhD right now, and if I get the H-1B approval, can I discontinue doing PhD? Absolutely not a problem. Can I continue doing PhD after getting the H-1B? Yeah, you can as a part-time basis, or you can do PhD even after you get the F1 visa. With regards to any day one CPT universities, to continue or stay in day one CPT universities, we already expressed our view. We don't want to express. We cannot encourage people to go to day one CPT universities.
I think we're out of time for today. Thank you everyone for joining. As usual, we will be back every Tuesday live at 5 o'clock Central Time. And if you want to have any specific consultation with any of our attorneys here at Reddy Neumann Brown, you can go to rnlawgroup.com and set up a consultation with us